Welcome to A Way Forward, the right to recover.
Welcome to A Way Forward, the right to recovery with attorney Craig Robinson. Craig is a partner at Robinson & Casey, PLLC, a Florida law firm focused on behavioral health law, including the Marchment Act and mental health guardianships. Much of Craig's work involves helping families understand when the law can open the door to treatment during an addiction crisis. I'm Lisa Mosby, and today we're talking about what Florida law actually allows when someone refuses treatment and families feel they've run out of options. Welcome back, Craig.
Thank you for having me, Lisa. It's great to be with you.
We're just a continuation on all these other episodes. There's just so much information about the Marchment Act and how we can help families. Craig, when families often reach a point where they feel they've run out of options, legally speaking, can someone actually be required to enter treatment in Florida?
Yeah, it's a great question, Lisa. And absolutely, they could be required to enter treatment in Florida. It's really what the Marchment Act is all about. And it really is intended for those families that feel like they've tried everything else. Oftentimes, Lisa, we'll get a caller, a family who at times, believe it or not, hasn't even asked their loved one if they will go to treatment voluntarily, right? And the response is always to that family, you should first have that conversation with your loved one. This is not a law that's intended for families who haven't tried to get their loved one to go voluntarily. It's for the family that feels like they've exhausted all of their options. But to answer your question, it actually can require someone to go to treatment voluntarily in Florida.
And we called it the Marchment Act, but is that actually a law that allows a court to require someone to enter addiction treatment?
It is. The more formal name of it is it's Chapter 397 of Florida law, if anyone is actually interested. But it is called the Marchment Act. It is named after someone named Hal Marchman, who really pioneered this law back in the early 90s and really saw a need for a law that was similar to laws that other states had for people with mental illness. But really what he saw was that there were a lot of people who were suffering from addiction issues in addition to mental illness, and that this is really what that law was intended for, is allowing someone who has addiction, and they can have co-occurring mental health disorders, to essentially be court-ordered to go to treatment. But really the law is formally, or more informally, known as the Marchment Act after Hal Marchman.
And then what conditions must be present before a court will approve a Marchment Act petition for treatment?
Great question. And I will also say, this question, as far as what conditions are required for someone to actually be court-ordered to treatment, is one where oftentimes families come to us and they don't really know exactly what the condition is, right? All that they know is that their loved one is acting in a manner which is really putting them in harm's way or putting those around them in harm's way. And so ultimately, what condition needs to be present in order for a person to be court-ordered to undergo an assessment is different than what needs to be present for someone to be court-ordered to undergo treatment. So it's kind of a two-phase process. In order for someone to be court-ordered to undergo an assessment, they have to have lost the power of self-control with regards to some level of substance use. That can be a result of alcohol use, illicit drugs, or even prescription medication. So it could be drugs that they're purchasing off of the street, or it can be medication that they're actually getting from a doctor that they are actually abusing. In addition to that, they have to be unlikely to voluntarily go to treatment. So we have to show that there have been efforts made to get them to go voluntarily, and they have refused those recommendations. And they also have to be at risk of self-neglect, and that self-neglect has to pose a risk of substantial harm to themselves or those around them in order to essentially meet the criteria to be assessed. Once they are assessed, the criteria shifts slightly. Now we need an actual qualified professional, which is normally a licensed therapist, that would be evaluating the person to determine if they meet the criteria for involuntary treatment, which is essentially that they have a substance use disorder, which is a diagnosis under the DSM-5, that they meet the criteria for that diagnosis of substance use disorder, that they have they have a history of lack of compliance with treatment for substance abuse, that they have in some way, shape, or form not complied with prior treatment for substance abuse. One point of clarification on that is that we do have some families whose loved ones have never been to treatment before. Maybe the family has known for many, many years that their son or their daughter or their loved one needs to be in treatment, but they've never formally gone. Courts in Florida have regularly determined that things like going to a family doctor and the family doctor making a recommendation that you stop drinking or that you stop using drugs, that can qualify as a history of lack of compliance with treatment for substance abuse. So it really can be anything involving a medical professional or a clinical professional where there's been a refusal of certain recommendations can qualify for that prong. And the other two are the same as the assessment prongs, that they have to be unlikely to voluntarily participate in the recommended services or be unable to make a rational decision with regards to their need for treatment. And then again, without treatment, they have to be at risk of self-neglect, and that self-neglect would have to pose a risk of substantial harm to themselves or those around them. Those are the criteria that need to be met in order to prove the case.
So we have the criteria, but what role does the court actually play in determining whether someone should be required to enter treatment?
The court essentially is overseeing this entire process, right? From the moment the case is filed in court, the court is overseeing it, and they're also making rulings on certain requests that are being made. The first request that's typically made in court is that the person undergo an involuntary assessment, right? So that's kind of phase one. Normally, when we file that, we're filing it on an emergency basis. We're saying to the court, we don't have time to wait here. Someone is in serious harm's way, and we would be filing a petition that would start the process, and then generally the court would respond relatively quickly. If it's pretty evident based on that petition that the criteria are met, oftentimes the court will issue an emergency order requiring that individual to undergo an involuntary assessment. If they're unwilling to walk in the doors of the facility, which is most often the case, law enforcement would be deployed to actually go pick them up and take them in for that involuntary assessment. And then from there, the court is really overseeing that the process. That assessment is submitted to the court. The court is then scheduling a follow-up hearing to review the results of that assessment and then enter any other further order that it sees fit, which is normally, in our case, a longer-term order for involuntary treatment. So the court would be seeing that assessment and then determining from there what is appropriate. But most often, that would be an order for involuntary treatment.
So, Craig, I see how the family gets the ball rolling, but then the court bears the heavy burden of helping the individual come into compliance. But many families worry about the personal rights and the legal limits. How do courts balance someone's individual freedom with the need to protect their safety and health?
That is a great question, Lisa, also. The reason why it's such a great question is because many states see this differently from how Florida sees it. You know, many states don't have this kind of a law. And the reason why they don't have this kind of a law is because they see this being a civil rights issue, and that really somebody should have the right to use drugs, and they should have the right to abuse drugs. And truthfully, if it ends up being that they do so to an extent that it ends their life or that something horrible happens to them, that many states look at that as a personal choice and a civil right that people have of free will. Florida sees it a little bit differently. And I think the language of the statute really speaks to that. The language of the statute says that if somebody meets the criteria for a Marchment Act, that they have been deemed to be incapable of appreciating their own need for treatment and be incapable of making a rational decision with regards to their own need for treatment. So really what the court and what the Florida legislature is saying is that this is a disease of the brain, which it truly is. Addiction is a disease of the brain. that renders somebody incapable of making choices on their own. So when we talk about civil rights, we're generally talking about the free will to make certain decisions. But when you're in the throes of addiction, and I think we talked about this on my last episode, that when you're really in the throes of that addiction, you are incapable of making a choice. When I was using drugs and alcohol to an extent that was really ruining my life, when I was in the throes of addiction, I was not making choices any longer. I could remember back to that and thinking to myself, I want to get out of this. I don't want to be doing this anymore. But it was like a gravitational pull that refused to allow me to make a decision to stop doing it. It was like I had no control over it anymore. And truly at that point, and I could relate to this on a personal level, but I think that somebody who's going through addiction, really deep down subconsciously, they do not want to be in this position any longer. They want to stop. They just don't know how to, and they feel like they can't. So really what the Florida law and what the Florida courts have said is that for an individual that's in this particular circumstance, we are going to protect them from themselves. Their brain is telling them that it is like quicksand around them and that there is no way out of this. So what we are going to do as a state and as a community essentially is come to their rescue, really is what it is, and protect them from what their brain is not allowing them to actually do, which is to make a conscious decision to seek treatment voluntarily. That's really what this is all about. And I really think that that's what the courts in Florida are really, I think it's groundbreaking, you know, what the Florida legislature is doing and what the Florida court system is doing. Just one other point on this, I could talk all day on this, but one other point on this, that I can't tell you how many people will come back to us after the Marchment Act is over and call us and say thank you, or call their family and say thank you, because they finally come to the recognition that they didn't have a choice in the matter, and that they had lost that power of choice. There's a term in most 12-step programs called powerlessness, right? It's actually the first step of recovery, is that we admitted that we were powerless over a substance, or we admitted we were powerless over alcohol or drugs. That's truly what Florida law is recognizing, that these individuals who are in the throes of addiction are powerless. So we need to give them the power to actually overcome their addiction.
And you mentioned the individual and then maybe the family coming back and saying thank you. Um, You shared a little bit about your personal experience, but could you illustrate what it looked like maybe when your family used the Marchment Act to help you enter treatment? What was their experience? Did you ever get any feedback from them about that process?
Yeah, so well, I will tell you, my family in particular did not use the Marchment Act on me. I ended up going. I ended up going voluntarily to treatment,
Okay.
thankfully. But we have talked to a lot of families after the fact. And I have to tell you that resoundingly, the feedback on this has been, I am so glad that I found you, and I wish that I had known about you sooner, because we might have been able to save a lot of pain for our family. So that is generally the feedback that we get from families. You know, I wish I could say that that's every case, Lisa. Obviously, we're talking about addiction and mental health. The most that we can do, we can't force that person to be sober and to live a long, healthy, and happy life. We can give them a chance. You know, we can give them a fighting chance and an opportunity to turn a corner, to actually develop that willingness to want their own recovery. And for the ones that actually do develop that willingness, which are many, those families are extremely grateful that they found out about this generally, and they wish they had known about it sooner.
So, Craig, are there situations where families believe someone should be required to enter treatment, but the law simply doesn't allow it?
There are. I will tell you that you know, there are some cases where there is no substance use disorder, where there's no addiction, and so there really isn't an equivalent for this for someone who truly just has a mental health disorder. So that's one area. One of the ways that we generally can accomplish that is through a guardianship, which I'm sure we'll talk a little bit more about on a later episode, but it's nowhere near as efficient as a Marchment Act is to get somebody to treatment. It doesn't happen nearly as quickly, and there's a lot more hurdles kind of legally to overcome. But that's one circumstance where someone doesn't have a substance use disorder. I wish that that would change, and I wish a new law would be developed to have an equivalent like this for someone with a serious mental health disorder. There are some other situations where, for instance, if someone isn't at risk of self-neglect, just because someone is using drugs, some people are functional addicts, I guess you might call it, where their life hasn't gotten to a point where they're truly at risk of self-neglect, and that risk of self-neglect doesn't yet pose a risk of substantial harm to themselves or those around them. But most of the cases that come to us that we take on are cases where the facts are really strong. That something horrible is about to happen to this individual if we don't intervene soon.
So, Craig, I want to wrap this up with one final question. For families who are in the midst of this struggle right now, what perspective can help them think about this situation more clearly?
Lisa, I will bring up an example that happens very often for us. It actually just happened to me yesterday, where I was on the phone with a mom who said to me, I can't force my son to be in treatment. I just can't do it. I'm not going to do it. And there was a mindset there from mom that there's no way that if I force my son into treatment that this is going to work. So I think the perspective and what I try to go to at that point is that you're not forcing. We're thinking about this as something that's forced. Really what you're doing is you're helping. You're really actually taking a step that is helping to remove that person's need to actually ask for help. They can't realize it on their own. So instead of looking at it as though this is forced treatment, I could never do this to my loved one, really I think what I wish families would look at it as is that I am taking a really courageous step to protect my loved one from themselves and to help them when they cannot help themselves, when it's just actually impossible for them to bring themselves to the point of helping themselves. And so that's really how I wish families would look at it, because I will just say one other thing. Last week, and this happens pretty commonly, unfortunately, in this, we were consulting with a father who was considering the Marchment Act and for his son. And that unfortunately, while he was waiting and kind of figuring it out and deciding, his son passed away of an overdose. So that's the reality of what we're dealing with here. And I hate, obviously, more than anything, getting those phone calls. And I really wish that we could avoid those phone calls, which is why I really wish that families wouldn't be as worried about the reaction that they might get and look at it as helping, not punishing.
And that's where we'll leave it today. Craig, thank you so much for sharing your insights and your experiences. I think that the stories that you share and the cases that you share really help to bring this home and touch the hearts of our listeners. Folks, thank you so much for listening to today's episode of A Way Forward, The Right to Recover. If you'd like to learn more about Craig Robinson and the work of Robinson and Casey PLLC, including resources about the Marchment Act and mental health guardianships in Florida, please visit robinsoncasey.com. And thank you so much for listening. Don't forget to subscribe, leave a review, and please share this episode with anyone who may need help today. We'll see you at the next episode.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.